Good morning, Mr. Halley. Good morning, everybody.
Good morning, Mr. Chair.
Are we ready?
We are.
Yes.
Mr. Chair, we had previously had one matter that was set down for today.
Yes.
That was the matter of Brigadier Kaba. Brigadier Kaba, unfortunately, has apparently gone for testing in respect of COVID-19. He's got counsel present today who wish to address you on an application for the postponement of today's proceedings.
Yes, okay.
The Commission does not oppose, the evidence leaders don't oppose the application.
Yes, thank you.
Good morning, Chairperson.
Good morning. You can just start off by placing yourself on record.
Chairperson, I am Manala M.E. I'm
Yes.
instructed by Maringa attorneys.
Yes.
And we both then appear for Brigadier Nyameko Kaba.
Yes.
Chairperson, as you'd have heard, there's an application that has been prepared requesting that the matter be postponed in order to allow some time for him to get better.
Yes, I saw correspondence, but I haven't seen the substantive application. If I could have that.
Yes, Chairperson, I'm just...
If I understand there is a substantive application.
Indeed, there is, Chairperson, and you will be addressed in that regard.
Thank you.
Thank you, Mr. Chair. Mr. Chair, the substantive application has only just been deposed to. The affidavit has only just been deposed to and handed to me, and that's the copy I've handed up to you.
Okay.
It's been deposed to, as I understand it, by Mr. Brigadier Kaba's attorney, because he wasn't able to go and make contact with him in order to take the oath, or to administer the oath.
Okay. That's fine. Where is this person who is supposed to sanitize before? Let him sanitize before you go back.
Chairperson, if I were to then briefly take you through the application.
Yes.
What is stated there, Chairperson, is that he's aware that he was to testify here. However, on Sunday, that is Sunday the 26th, he experienced some pains which were later confirmed as to be symptoms related to COVID-19. He approached a doctor who then confirmed the symptoms to be as such and then directed that he should undergo testing and in the meanwhile isolate himself. There's also then an indication of an outbreak in the offices where he works, and there's been a couple of cases confirmed in that regard, and it seems then that the suspicion is that he might have contracted it from that set of facts. And on those basis, Chairperson, we request a postponement. And we had discussed the possibility of a matter standing down to enable the results to come out, which we estimate to be by no later than Friday. And then after, you should then be in a position to decide how to deal with the matter going forward.
Yes.
Thank you, Chairperson.
No, that's fine. It does sound like a genuine case. And that there is a need for him to isolate himself. Of course, even the building where he works, I think there is a notice to close it
That is indeed
down
the
or
position.
something for the time being.
Yes, it has been closed.
Yes, yes, yes. No, that's fine. I think what I'll postpone the hearing of his evidence to a date still to be determined, and as soon as possible, let the commission know what his position is, so that a date can then be arranged. Or it may be that we'll arrange the date anyway. And it won't be too close, so it will allow him enough time to recover in case the results are positive. And then if for some reason there is still a problem with the next date, then we'll take it from there.
Thank you, Chair.
Yes. So the hearing of is it Brigadier or Major General?
It is Brigadier.
Yeah, the hearing of the evidence of Brigadier Nyameko Xaba is postponed to a date that will be determined in due course in the light of his situation as described in his affidavit.
Thank you, Chairperson.
And you are excused.
Thank you.
Thank you. Sorry. I saw Mr. Ntlego's hand being up earlier on. Has the need fallen away?
No, Chair, good morning.
Yeah, good morning, yes.
I may as well declare, Chair, that I'm still on the good side of the law. But indeed, the need has not fallen away, sir. Yes, I would still like to address the Chair in respect of two particular matters.
Oh, okay,
Yes.
okay, all right, okay.
Yes, I would like that opportunity, sir.
Okay, no, that's fine.
Thank you very much.
Let me hear, Mr. Halley, are you ready that we start with what Mr. Tlego wishes to raise, or would you like
wasn't
to
aware
deal
of
with
any
something?
Pardon me, Mr. Chair, I wasn't aware of something specific, but he's at liberty to
Yeah,
proceed.
okay. Go ahead, Mr. Tlego.
No, thank you very much, Mr. Chairman. I do so precisely, Chair, because I'm here to present my evidence, but largely with my commitment and the view that I also by all means need to try and assist the Commission to arrive at a better understanding of the matters at hand and so on. Now, during yesterday's
Well, maybe before we proceed,
Yes.
I just confirm that the oath you took yesterday continues to apply today.
Yes, it does, Mr.
Yes.
Chairman. Thanks very much.
Yes.
Yesterday, during proceedings, we got to a point where and I think at some point the Chair also asked very pointedly the whole question of what were the reporting lines. And I think it's during the time when we're trying to figure out, the issues of sequencing relating to the correspondence and the interaction between myself, then as Minister, and the former Executive Director of IPD, Mr. McBride. Now, the starting point, and of course, I've had to try and think and recall some of the issues. And I still stand by the view that says, given the number of years in between the role that I played and now, it's almost impossible to recall everything, every bits and pieces of the happenings then. However, I have no basis, for instance, in regard to the correspondence of the 24th and the 26th of November, I have no basis to then say I do not either identify nor trust that those pieces of correspondence. Indeed, all it does, it establishes that there was an interaction on my side, for an example, requesting IPID to surrender the docket and certain information relating to the renditions case. I think it's important to stress that that point has been articulated as the eagerness of the minister to interfere with the independence of IPID. And that's incorrect. Precisely as I had answered to the Honorable Chair when he posed this question, what were the reporting lines? The reporting lines were direct. The IPID Executive Director reports to the Minister of Police. But also there are provisions in the IPID Act. I think it's Section 7, subsection 12, as you know, also Section 28, subsection 1, which entitles the minister to ask for any information pertaining to the work of IPID or the executive director and so on. So I think at that point, you know, it's important because then it has got to relate to this question that the chair wanted to be clarified by in terms of the reporting lines. And I think sequentially, there was a need for that in the light of the allegations of the two reports. And also what had been alleged is the withdrawal of the docket from the National Prosecuting Authority. So it became important because it was in the context of the ongoing work that I had, on the one hand, assigned to the reference group, and they had produced a particular report at some point. And of course, there was a need also for further investigation to clarify ourselves about, you know, what happened, how it happened, and why it happened, and so on. And then decide in terms of what it is that institutionally, from an accountability point of view, we therefore needed to do and undertake. So that's in respect of that issue. I think the second one that I would also like to address the chair about relates to the two reports. In fact, I battled to sleep, you know, when I reflected on the articulations of the chair last night, wherein the chair poses this, of course, I think as a question, not necessarily as a statement, and say, but what's the problem with the signing of the two reports? Then I thought maybe there is a need to try and clarify this issue, and I hope I would assist in this in that regard. Now, IPID by law is to investigate the conduct of the police. But that investigation can also split into two ways. It could be relating to investigating the police for acts of misconduct, okay? But it could also be police in relation to criminal crime and criminal investigation and so on. In this instance, we're talking about a criminal investigation undertaken by IPID, signed off in January the 22nd of 2012, if I'm not mistaken. No, 2014, it should be. Now, and it's not just any other report. It's not just any other report. It's a report that was a product of investigation by a chief investigator, who then signs it off and then refers it to the National Prosecuting Authority for a decision to prosecute, and that's in January. Now, there is no provision, either by law or even convention for that matter, that you would then have a so-called second report, which in itself does not nullify the first report nor the withdrawal of that report, for an example. Having an equal or a similar status with the National Prosecuting Authority. In other words, you have a report of the 22nd and the report of the 18th of March with a similar, more or less similar content and so on, but at a closer look, you can clearly see that there has been tampering with evidence contained therein. Now, so it's not a report that corrects the cosmetics and grammar and language and so on. The second report is not a report that does that. All it did, it plucked out material evidence with the view to influence the recommendations at the end. And I think that's where the fundamental problem is. Now, I'm raising this thing precisely because I think we should appreciate that you have a legislative arrangement on the one hand between IPID and the National Prosecuting Authority in terms of the referral of such reports. On the other hand, there is administrative responsibility, and that administrative responsibility lies with the chief investigator to sign off that report and recommend it to the NPA. The small thing that I'm probably forgetting to mention is that insofar as the criminal investigations, it is usual practice that the National Prosecuting Authority would assign a prosecutor and or prosecutors to assist IPID in an investigation. Okay. But at some point they have got to step off from that particular exercise. In this instance, it was Advocate Musing and Advocate Mwelitze, I think, of the NPA, who were assigned to this particular investigation to assist IPID in the production of the investigative report of January 22nd. Now, the anomaly is this then, is that when we engaged with the National Prosecuting Authority, particularly these respective advocates, they did not know anything about the second report. Now, if indeed the second report was a valid one, as it has been claimed, for an example, then the National Prosecuting Authority, and particularly Mr. Musing and Mwelitze, would have been in the know of the production of that report. Okay? So, and that's where the disjuncture, in a sense, lies in. So, and therefore, it should be understood in that context, because I think the misunderstanding is that when we talk about the second report vis-a-vis the first report, it's, you know, I think there's a view that wants to say, no, those were just the grammatical sort of changes and so on. It's not true. The fact of the matter is that, and we will show it here, that you distinctively, in the body of the two reports, have deletions. Have deletions. So if any one of us, institutions of state, on matters such as this, we will want to perpetuate that kind of narrative, then I think we must accept that the South African society is not secured. Because if you are going to have agencies of state that can willy-nilly interfere with investigative reports and processes and so on, and alter and temper them, with a view to change recommendations at the end of such reports, then there's not going to be a public benefit insofar as matters of fairness, justice, and humaneness, for an example. So that's largely the problem. So I thought, let me just clarify this particular matter, because I think there has been a lot of misunderstanding around it. And I think it would be of benefit to the proceedings of the Commission that we begin to also delve into the issue of the two reports. Because even in the public mind, the question is, what are these two reports that we keep on speaking about? And what's the difference between the two of them? And how come we came across a situation such as that? So I sincerely do thank the Honorable Chair to grant me this opportunity to try and clarify these particular matters. Thank you very much, Chair.
No, that's fine. Indeed, that's a very important part of what the Commission wants to look at in relation to what Mr. Kuba, Mr. McBride and Mr. Kuba may have said in relation to your involvement in regard to the reports. I think that Mr. Hali is moving towards that issue, so I will allow him to do that. I think that we must deal with that issue quite properly, because if you did watch when Mr. McBride and Mr. Kuba gave evidence, you would have seen that I have certain things that I didn't understand, which I would like to be dealt with regard to every witness, including you who comes here who was involved. Give that witness an opportunity to enlighten me and make me understand whatever I might not understand, because when you are not involved in the situation, you might not see things in the same way as somebody who is involved. But it's important for me to articulate what my areas of concern are, where I have areas of concern, because that gives the witness, that gives you the opportunity to address those concerns head on. So that if, after you have addressed them, I still don't understand, it should not be because you did not get a chance to address them. It should simply be because you did your best, and for whatever reason, maybe I still don't understand. So it's important. But I just want to mention that with regard to one of the issues you have raised, connected with a question I asked yesterday, where I also referred to the independence of IPET. The idea was simply to say, to the extent that there is some independence on the part of IPET, one needs to understand the extent of that independence vis-a-vis the minister. So that's why I was saying, what are the reporting lines, so that one can see to what extent how the relationship is supposed to work. But as I say, I think Mr. Hali is moving towards a point where we can engage with that area of the reports quite in depth, then we can deal with it. But if there is something you think should not wait until that point, you can deal with it now.
No, thank you very much. I really do beg your indulgence also in this regard. I forgot one small thing, but
yeah,
you also, are mentioning a critical part around the issue of independence, and I think we will get to a point also to take into account the reflections as well as the subsequent sort of order by the Constitutional Court in regard to the issue of independence, because I think it's a critical point.
Yes.
Now, the one thing I forgot to deal with when dealing with this thing, and apologies for forgetfulness, is that we should be alive, all of us, to the fact that people died. And died through, allegedly, agencies of state that were supposed to uphold the law. And I think if we fail, whether it's institutions of state and South Africans in general, to be alive to that fact, then that would mean we're losing our humanity in a sense. And I think we should, when we deal with the question of the two reports, we should know that between the question of the so-called two reports, they are human lives, people that really died, regardless of whether they were guilty of any other whatever and so, but they died in the hands of state agencies and so forth. Now, I'm raising this point, Honorable Chair, because I've had a disturbing articulation, and in fact, this articulation I also even picked it up not only in Mr. McBride's affidavit, but also even in the correspondence of the Commission, when they wanted me to forward reports that were produced by the reference group. There is a reference to something called the so-called rendition case. Now, I have a problem with that articulation because rendition took place. It's not so-called. There was an investigation, the NPA was involved, and so on at some point. So it's established, there's a fact, it's factual. It took place. There are statements in that regard sworn to by different individuals who also played a role in such an exercise and so on. So it's not so-called, it's factual. But if we were to continue with the view that says it's so-called, so we must also accept that we shall develop a concept called so-called deaths, because there were people that died. So we'll then say, these so-called deaths and so forth. And I don't think we can get to that point. For me, it bothers me from a conscious point of view that we can't begin to develop concepts and notions of that nature, particularly when we're dealing with human lives. And, yes. that's a point that I forgot to also include in the question of the two reports.
Yeah, no, I don't want us to spend a lot of time on it. I hear what you say, but I remember that some people say when somebody has been arrested by the police and it is said that the person is a suspect, and they saw that he or she killed somebody, they say, we don't understand why he is called a suspect, because we know he killed so-and-so. he killed so-and-so, so why is he called a suspect? So, but I don't want us to spend time on it. Let's move on. I understand where you come from, and yeah, okay, all right. Mr. Halley?
Thank you, Mr. Chair. Without going into too much in relation to the so-called rendition case, there was a docket opened in that matter which was ultimately handed over to IPD. You're aware of that?
Which was ultimately handed over to NPA?
To IPD. There was a docket in respect of the rendition matter. Mm-hmm. That docket was ultimately handed over to IPD for further investigation, and IPD then ran with that docket. In other words, continue to investigate the allegations that had been made in respect of the rendition matter.
Chair, I'm aware of an investigation undertaken by IPID, and subsequently that investigation referred to the National Prosecuting Authority.
So the case that relates to that, the case has a case number and it's got investigators in it. That case is the official case number that is assigned to it. The rendition, the reference to the so-called rendition case, Mr. Nhleko, is to the fact that the media had referred to it as the rendition matter, or the rendition case.
I don't seem to get you, Mr. Hali. You're saying we called it so-called because the media referred to it as rendition.
The official title, or the official reference to it is the reference to the case number in respect of the docket that had been opened. That's the official thing. So everything else is to the so-called rendition matter because everybody understands what that's referring to. Then. You understand that?
No, I don't.
Okay. Well,
I don't.
Let's move on then.
Yeah. Okay.
Now, you've referred to two issues that you would like to raise. The first issue was in respect of Section 712 of the IPID Act.
Chair, maybe just to correct the...
Sorry?
Yes, if you're checking, so that the witness is not, so that an incorrect proposition is not put to the witness. The matter has been referred to officially as a rendition matter. And we can take it from the report. So I'm looking at official documents. The first report is a report of 25 June 2012 of the Civilian Secretariat.
I'm trying to make sure that we don't spend time on whether it is a rendition matter or so-called rendition matter. But I accept, Mr. Mukhari, that if the document or report or docket referred to it as a rendition matter, no impression should be created that the document or report said so-called if it didn't say so-called.
Yes, indeed. I was just correcting that the official documents refer to it as a rendition.
Yes.
And that's the report of 25 June 2012 of the Civilian Secretariat and the report of the reference group of 22 November. Thank you.
Okay. I simply say for present purposes, I don't have any problem with somebody who refers to it as the so-called rendition matter, because they might not be sure whether it falls within, what happened falls within what is referred to as rendition, or they might not even know what rendition means. So I don't have a problem with that. Anyone who calls it rendition matter, that's fine as well.
Thank you.
Okay, let's move on.
Now, Mr. Nhleko, you refer to Section 712 of the IPID Act to make the point, as I understand it, that there is in fact a reported line between IPID or the executive director of IPID and the minister's office. Do you understand that correctly?
Yes, I do.
Well, let's consider Section 712. Section 712 says, and Mr. Chair, it should be in a legislation bundle. We've marked it Exhibit Y legislation and authorities bundle.
Will the witness, I think the witness should have the benefit of being given the same thing. They'll give it.
No, it's fine. I'll listen.
You know, you'll follow.
I'll follow.
Okay, all right. Just read it, Mr. Harry. He will.
Thank you, Mr. Chair. It says the following. The Executive Director must at any time when requested to do so by the Minister or Parliament report on the activities of the directorate to the minister or parliament. Is that the provision that you're relying upon?
Yes, that's what I pointed out.
Now, of course, he is required under this section to report to you on the activities that have been conducted. It might even be an activity related to a specific matter, as in respect of the rendition matter.
Right.
Now, it certainly does not, unless you tell me otherwise. Section 712 doesn't require you or require the executive director to hand over a docket to the minister or to parliament. Would that be fair to say?
No, I think that's a matter of your interpretation versus my interpretation, really. We may decide, Chair, whether we want to spend the whole day trying to unpack the conceptual understanding of what that section is.
It depends on the point that Mr. Halley wishes to explore. Mr. Halley.
Thank you, Mr. Chair.
Yeah.
The minister has an executive function relative to the SAPS, relative to IPID. Would that be fair to say?
The Minister of Police and that ministerial portfolio in it has got institutions that report directly within that particular portfolio to the executive authority there, who then is termed as the Minister of Police.
So I'm not sure if I entirely follow. You're saying that the minister has different portfolios.
The Minister of Police is, for amongst other things, made up of the South African Police Service, DPCI, IPID, the Private Security Industry Regulating Authority, as well as the Civilian Secretariat for Police, which is basically housed within the administrative section of the ministry and so on. So that's my understanding of that institutional arrangement.
No, that's fair enough. But the point is that it's an executive function. The minister is a political appointee, correct?
Correct.
And the operational matters get done, or the operational head of the SAPS would be the National Commission of Police.
Right.
Would that be fair to say?
No, that's fine.
Then, insofar as dockets are concerned, when a docket, as far as a docket is concerned, when an investigation needs to be conducted, or if a docket needs to be given to any person at an operational level, that docket must go to the, or can go to the National Commissioner.
No, not insofar as IPID is concerned, and I think we need to understand the mandate of IPID vis-a-vis the police service. You wouldn't envisage a situation where then the police are handed reports that are about them. It wouldn't make sense from the side of IPID, because IPID investigates the conduct of the police in respect of criminal matters and other areas of misconduct.
They would investigate, they could investigate even the National Commissioner.
They would.
Yes.
They would.
Yes.
That's what the law establishes.
He falls within their jurisdiction in terms of investigation as well.
Correct.
Yes.
Okay. Well, let's just go through the provisions of Section 7, and it actually would be useful.
So I'm sorry, just to complete the point which I think you seek to make. The point you seek to make is IPID has jurisdiction to investigate conduct by all people who are police officers under SAPS. Or maybe it goes beyond that, but
No, it does go beyond that.
yes, okay.
It's all police officers, there's South African Police Service and municipal police services. Yes.
No, I know about the municipal, but because you were not responsible for them, I'm not talking about them. I was talking in terms of SABC to say it's only police officers, clerks, and other people who would not fall within their jurisdiction, isn't it? Administrative staff who are not police officers.
There are admin staff that are defined outside of the South African Police Act.
Yeah.
In other words, they're part of the Public Service Act by definition.
Yeah.
But you could also find admin staff that are classified under the South African Police
Yeah,
Act.
if you are a police officer but
Yes.
performing admin staff, you would
yeah.
still fall under them.
Yes, you would.
Yeah, but if you are not a police officer, then you would not fall under them, even though you are within SAPS.
Yes.
Yeah.
That's correct, yes.
So the point you are making is that the IPED has jurisdiction to investigate even the national commissioner, and that there is a reason why the executive director reports to the minister.
Right.
And the reason is that if they were to report to the national commissioner, there would be a serious risk that the national commissioner could be the subject of investigation or people quite senior close to him. And that's not an ideal situation, and that's why the law says they must report to the minister.
Yes, I think that's a correct understanding. Otherwise, their work will be severely polluted.
Yes, because the minister doesn't fall under their jurisdiction. He is not a police officer.
Correct.
Yes, okay.
That's correct.
Thank you, Mr. Chair. Mr. Nhleko, thank you very much for that, because in fact you are in part right as far as that's concerned. I'd like you to consider Section 7.4 of the IPED Act.
Okay. No, go ahead.
If you look at, there's a
I'll
file
make my
divider.
attempt to listen.
If you go to file divider 8,
I think he is quite happy that you go ahead and put the question.
Very well.
He will be able to understand.
thank you, Mr. Chair.
And if he has to look at the act, he will feel free to do so.
Section 7.4 says the following: the executive director must refer criminal offences revealed as a result of an investigation to the National Prosecuting Authority for criminal prosecution and notify the minister. Have you got the provision, sir?
Yeah, no, I'm listening. I hear you very well.
And notify the minister of such referral. So what the minister must be informed of is the fact that IPED has conducted an investigation. IPED has come to the conclusion that the investigation has revealed the commission of an offence, and IPED must then refer the matter to the National Prosecuting Authority for prosecution and must merely advise or notify the minister of such referral.
Mr. Halley, I'm still trying to find where the...
It's page 152 of the bundle. It's the file divider 8, pardon me.
152.
The 152 of that bundle.
Legislation and authorities.
Correct, Mr. Chair.
Okay. Thank you.
Thank you, Mr. Chair.
And you are referring to section?
It's section 7, sub 4.
Okay.
So what you, as the minister, have to be informed of is the fact that IPID has made a referral to the National Prosecuting Authority for prosecution of a case that it has investigated, and that it believes, or that IPID has come to the conclusion that the case should be prosecuted. Not provide you with a docket. Would it be fair to say that Section 7 sub 4 does not suggest in any way that a docket has to be provided to you?
No. Generally speaking, in the application of institutional instruments, there are ideal situations. But in this instance, I think, Mr. Halley, you might be missing one particular point. The one particular point is this. You already had allegations of misconduct leveled against the very same IPID. So, in other words, very same IPID was, quote unquote, somewhat tainted because of the issue of tampering. Right? And that matter gets brought to your attention as the executive authority to then say, but there are these allegations of serious misconduct which deals with the question of tampering and or deletion of material evidence from one report to constitute another report. What are you doing about them?
But let's sorry.
So I'm saying, yes, indeed. In fact, this provision was applicable and it applied. You know, you would always get reports about, you know, as minister, about this is the amount of work that we're doing, this is whatever case, and so on and so on. So you'll get such reports and so on. But there was a pointed specific problem. And that's the question of the two reports.
Yes. I'm really concerned, and I appreciate that explanation, and we'll get to that in a moment. I'm really concerned with the question of whether Section 7 sub 4 places an obligation upon IPID to provide the minister with the docket.
It makes a provision for submission of information.
To notify you of the fact of the referral.
No, I'm talking about 712. Information that the minister would be required.
Sure. What I'm trying to suggest is that I want to take it step by step. And I certainly won't be unfair to you where I'll try to compel you to answer a question in isolation, but I just want to go through it step by step. Okay. And once we've finished with the section, I'll give you an opportunity to tell me where you find the provision that allows you or imposes an obligation upon IPID to provide the minister with a docket. Right. Is that a fair way in which to deal with it?
No, I'm listening, say yes. Go ahead.
Pardon me?
No, I'm saying I'm listening.
Okay.
Go ahead.
So you'd be satisfied that Section 7.4 is not that provision that imposes an obligation upon IPID to provide the minister with a docket?
I think that's a matter of interpretation, sir.
Okay. So let's go to the section...
Well, maybe let's put it this way. Is your understanding of it, Mr. Nhleko, that it includes a docket as part of what the executive director must or may send to the minister? Is that how you understand it? Is that how you understood it at the time? Or you don't have a specific understanding of it, but you are not sure whether you would agree with the interpretation that Mr. Halley puts forward?
No, Chairperson, as I had alluded to this point earlier on, you had a specific problem and a very pointed problem. You therefore required all the necessary information to enable you as the executive authority to delve into the identified issues. and deal with the allegations. Now, I'll just make an example. If, for an example, you needed to evaluate and establish whether there are two reports, and is it the 22nd versus the 18th of March and so forth, the issue of the docket would also enable you to be able to look into that, okay? And how, and what are the issues that constitute the issue at hand, you know? Because that's what the issue of the docket, that's how it would be useful to yourself as a person who's trying to look into what the facts are in relation to that. But if you choose to be narrowly administrative, you'll talk of the docket as the docket and a file that moves from one place to another, and that's it. But if it's in relation to establishing the facts and the happenings about the whole question of what happened in this particular matter, you will definitely need to look into the content and statements and everything else that constitute that particular document.
Yeah, you see, I understand what you are saying, but I think the problem is that Mr. Halley is not there yet.
Okay.
He is at a prior stage of simply seeking to establish what your own understanding is of Section 7.4. Of course, you might have an understanding of Section 7.4, and you might say, this is my understanding of Section 7.4. This is how I understood it, whether my understanding is right or wrong, but this is how I understood it at the time. I'm not a lawyer, as a minister. This is how I understood it. And then Mr. Halley can say what he wants to say. If he says, no, it's wrong, it's not wrong, you are not a lawyer, okay? But you may have had an understanding of it. But it is also possible that you didn't necessarily have an understanding of it, in which case all you say is, look, I'm not sure if I had an understanding of it, or I'm not sure that I applied my mind to what it means, or I knew what it meant. But if you ask me why I asked for certain information, I can explain to you why I asked for that information. So at this stage, he just seeks to establish whether you do have a certain understanding of what it means, and then once he knows that, he can move forward and then maybe go to the stage that you have dealt with already.
No, thanks very much, But I really do believe that I've responded to that question.
Yes.
You know, of course, it may not be the legalistic kind of.
Yeah, no.
I think correctly, as you say, you know.
Mr. Halley?
I'm not a learned friend of.
You obviously had an understanding of Section 712 and what powers Section 712
Right.
invested in you, or what obligations it placed upon IPID. The question I would like to know is whether that was the understanding you had at the time, i.e. in 2014, or is this an understanding that has come to you subsequent to 2014?
No, I also do think I've responded to that question, Chair. I've cited that particular section as well as Section 28 of the same Act. The one thing that I may not necessarily have at my disposal is also the IPID regulations, because they also do talk to that matter.
Now, I think my question is a relatively simple one. If you're unable to recall, you're welcome to say that. If you had a specific understanding at that point in time, then of course you would say that. If you had an understanding that only became apparent to you later on, as you got involved in more and more court cases around these issues, then of course you're welcome to say that as well. The only question I'm asking you is, was that your understanding in 2014 when you were having interaction with IPID on the matter of the rendition docket?
I've responded to that question, sir.
Okay.
Just respond again, Mr. Nhleko, so we can make progress.
No, I've responded to that question, Chair.
Yeah,
in
what was the
terms of
response?
That the issue of asking for information on the side of IPID is and was informed by the relevant section in the IPID Act. And I cited section 7 and section 20.
One second, Mr. Nhleko. There was a time yesterday when I could hear you very clearly. I don't know whether you were coming closer to the mic.
Oh,
but
no,
I see the aircon is also making some noise. Yeah, if you come closer to the mic, I think I can hear you clearly. Will you just start?
No, apologies,
start
apologies,
again.
Chair. And
It's not your fault.
Yes.
Just start that answer again. What was your response?
And may I also be congratulated by its chair for looking at him most of the time, this time around.
I think the record will reflect that you are looking at the chair today, unlike yesterday.
Yes. Thank you very much.
Yesterday you were looking away from the chair.
Yeah, no, I know. I had difficulty to swing around the seat and so on. Thanks.
Yeah, no, that's fine.
I was saying, look, I responded to this question, Chair, that this very same act was in existence at the time. And section 7.12 and 28.1 of the IPID Act, as well as regulation, I think it must be regulation 15, deals with the issue of information from the side of IPID as requested by the minister's executive authority. So I think that clarifies that particular
Yes.
matter.
Effectively, is your response that those sections to which you have referred in the IPID Act and the regulation that you have referred
Regulation 15, yes.
to entitles the minister to request certain information from the executive director, and that information you say would include a docket, or you are not going that far?
I couldn't get your last part.
Yeah, I'm saying, are you saying that those sections of the IPID Act to which you have just referred and the regulation entitled you as Minister of Police to request certain information from the Executive Director of IPID, and the information you could request could include, in a specific case, a docket?
Yes.
Okay.
Yes, it would.
If I can inquire from you, the view that you held, and we understand that you held that view at that point in time, i.e. in 2014, was that a view that you had come to on your own, or had you sought legal guidance before arriving at that conclusion? In other words, did you seek an opinion from any advocate, attorney, or a lawyer?
Sure. How is this relevant, Chair?
Sorry, I didn't hear that.
No, I'm saying, how is this question relevant? Whether I got an opinion from a particular lawyer or somebody and so on. How is it relevant?
It may be relevant in the sense that if you relied on legal advice, you might not be criticized for it. so those who advised you may be criticized too. But if it's your own understanding, then you can be asked to explain your understanding.
It's a nice explanation and interpretation of the Chair. I'm just wondering whether at the level of political management, those things are ever applicable.
Yeah. Well, you see, actually the question might help you, Mr. Nhleko. The question might help you, Because,
Yes, yes. No,
yeah,
no, no.
well, let me not say because of what Mr. Mukari is laughing.
Yes.
So I'm afraid I'm going to ask you to answer the question.
Yeah, no, I will answer the question. It's just that it sounds like the chair is trying to save me in some future trouble of sorts. Yeah. But nevertheless, Chair, in the ministry, of which I was, the head, we had firstly, you had a legal function attached to it. You also had I know that I had the legal advice and so on. I think also the deputy minister and so on. So, you would certainly rely on advice when it comes to matters such as this. In other words, legal matters, broadly speaking.
But the question would be, in regard to this understanding, was your understanding based on that legal advice?
Yes.
Okay,
Yes,
that's
it
the
was.
answer. Okay.
So you had actually taken the trouble to seek legal counsel on whether you had the power to do that which you ultimately did do, i.e. to call for the docket from IPID.
Yes, sir.
And the opinion said that you could do exactly what you ultimately did do.
Yes, I did, sir.
Okay. And was that internal or external counsel that you sought the opinion from?
No,
I
it was
think it's that internal.
yes, it's an
Yeah.
internal function.
Okay. Now, you then called for the docket, and we're talking now about in the year 2014, you called for the docket from IPID. Correct? You called, I referred you to the letter of 24 November 2014. Mm-hmm. I did so yesterday. Do you recall that?
Yes, I do.
And the docket was provided to you.
I think it was.
It's been the evidence that the docket that had been provided to you, it was the evidence certainly of Mr. McBride, that the docket that was provided to you contained the 22 January report, but unsigned, and the 18 March report signed. And I'm talking now about the report of IPID into the rendition investigation.
No, that's incorrect. The signed report is the report of the 19th. No, it's the report of the 22nd, which was then referred and filed with the National Prosecuting Authority long before Mr. McBride assumed the role as executive director of IPID. Now, I accept that also the 18th, the so-called report, was also signed and countersigned by two other individuals as well, which in itself I'll also maybe at some point talk about it. But the report of the 22nd was already with the NPA for a decision to prosecute or not to prosecute.
So I'm not sure if I'm following you. I'm making a specific proposition. The proposition that I'm making to you is this.
Yes, I'm also not sure if I follow the point you are making, Mr. Ntlego. As I understand, the question from Mr. Halley sought to confirm that what the executive director of IPID sent to you included the two reports, but the one of 22 January was unsigned, the copy he sent to you, but the one for 18 March was signed.
Correct.
So he sought to establish just that, whether you have a recollection that what the executive director gave you included those two reports, but the one for 22 January being unsigned. Is that something you remember? Is that something you are not sure about?
No, I've always had the assigned copy.
Okay, you have
the
never
report
had
of
an
the
unsigned
22nd
copy.
of the
Yes.
22nd of January and so on.
Yes. And the copy that you had, is it one that came to you from the executive director? It's not one that may have come from IPED, from the NPA or anything like that? In other words, your source, was it only the executive director?
No, that wasn't the source. It wasn't the source.
Yeah.
Remember that I made my own inquiries
Yes,
Chair,
yeah.
on this particular issue. And it's a matter that was there before I came in as minister and so on. So it was a matter that was also part of the institution there. Because among other things, for an example, at the time when the issue of the report of the 22nd was spoken about as the report that's being altered and so on, I had no idea about the work that was done before by the Civilian Secretariat, for an example, which led to IPID conducting that investigation, which then was concluded on the 22nd of January. So I'm saying it's through my own inquiries, that's the report that I found.
So there is a report that you found when you came, or that you got through your own inquiries.
Right.
And that report of 22 January was a signed report.
It's a signed report.
But do you have a recollection whether the executive director did provide you with the two reports, or is it something you can't remember?
It was only one report, and that was the report of the 18th.
Of the 18th of
Yes,
March?
of March.
It did not give you
No,
two?
not the
22
not the
January
22
one? Okay.
January one.
All right.
So the 22 January report signed was given to you from other sources, but the 18 March report was given to you by the executive director of IPID. Do I understand that correctly? Okay, let's take it one step at a time. 22 January report, the signed 22 January report was given to you by some source other than the executive director of IPID.
Okay.
Is that right?
Yes, that's correct.
And can we be specific as to who gave you the signed 22 January report?
Look, I instructed members of staff in the ministry to establish the issue of this report, whether we had it in the ministry and so on. Now, the ministry chair is made up of various individuals and functions in there. Okay, so if you instruct people in the office, they will go different whatever ways to try and establish whether is that the kind of a thing that can be obtainable within the ministry, and so it goes. So that's how it came about.
In other words, does that mean you can't remember who exactly gave you that report?
Yes, I cannot. I mean, there's no way that I would. I mean, you leave an instruction for people to try and find this report. At some point, you come back, it's on your desk. You know, that's the kind of thing.
Okay.
And we're speaking here now because we know that the executive director of IPID provided you with the docket and with the signed 18 March report on the 26th of November of 2014. So what I'm asking, what I'd like to know is when he provided you with that docket and the signed 18 March report, Did you already have the first report, which was the 22 January report that had been signed?
Yes, I did. I did.
And did you, when he gave you, that is the executive director of IPED, gave you, furnished you with the 18 March report, was that the first time you laid your hands on the 18 March report? Or did you have it from other sources already? The 18 March one?
Yes, it's possible. It's possible, but remember, Chair, that the allegation, as it were, said there was this report which makes different recommendations from the report of the 22nd and so on. And that we needed, of course, to do some work around that. So it's very probable that, that was the first time I saw, because I sat with the two reports then, having got to look at what were the said the differences as alleged, for an example. Yes.
But are you saying it's very probable that by the time the executive director of IPED gave you the 18 March report, you already had one, or are you saying it's very probable that it was the first time that you were laying your hands on the 18 March report when he gave you?
No, I'm saying it's probable that it was the first time I laid
Your hands on
my
it?
hands
On the 18 March
yes,
report?
the 18 March report.
Okay, no, that's fine.
Chair, could I think there's a famous thing these days that's called a comfort break.
Oh, well,
Yeah, I think it's a
it is the
code
right
word,
time.
It's a code word for
It's a
trying to
euphemism.
do something else.
No, it is the right time. We normally
Yes.
take a break at 11:15, and it is 11:15.
Oh.
We'll take the tea adjournment and we'll resume at 11:30.
No, thank you
We
very
adjourn.
much. All right.
All rise.
Long. It's a long walk to freedom.
Let's continue. Your mic, Mr. Halley.
Thank you, Mr. Chair.
Mr. Ntlego,
Yeah, Chairperson.
there is a light next to you in the event it's dark where you are and you want to read something. I hope it is working. It is there specifically for the witness, should you need it, because I've seen in the past that sometimes it can be quite dark and sometimes the witness can't see when they want to read. So I just want to mention that it's available to you.
Thank you very much, Chair, but it's not working. As and when it works, I'll do what Moses said in Genesis of the Bible. I'll inform the Chair accordingly. Thanks.
Well, maybe during lunch break they'll have a look and see why it is not working.
Yeah.
Okay, thank you. Mr. Halley.
Thank you, Mr. Chair. So, if I understand correctly, Mr. Ntleko, on the 26th of November of 2014, you would at that stage have had two reports, both signed. The first report dated 22 January 2014, the second report dated 18 March 2014, one supplied to you by a source that you're not sure of at the moment, but within your structures within the SAPS. The second supplied to you by IPID, directly by Mr. McBride. Do you understand that correctly?
Yes, I think that's what we spoke to.
Now, on the 6th of December of 2014, you gave Mr. Dramat a notice of intention to suspend him. And you ultimately...
Can we correct the date, Chair? Is the 9th of December.
Oh, okay,
Yes.
thank you.
It is actually recorded in the judgment of Helen Suzman Foundation versus the Minister of Police, who will hand it up, then it has all the dates. It is so very helpful.
Okay.
Yes.
Thank you, Mr. Mkhari.
Thank you, Mr. Mkhari. Thank you, Mr. Chair. At any rate, you ultimately suspended him on the 23rd of December of 2014, correct?
I'm not sure of the date, but it was in December, yes.
Now let's just go back, because according to Mr. Kuba, his testimony was, and he filed an affidavit to this effect, that on the 6th of December of 2014, he was approached by General Bernie Mhlameza, who informed him that he should watch the news because there was going to be a hit on Dramat. Now, if I understand your testimony correct, you dispute in the fact that you would have communicated that information to Mr. Mhlameza. Is that correct?
I just wonder as to why would I do that, Chair. I supervised the General Dramat directly, and that's precisely it. So as to where this thing comes from about General Mhlameza, who then engages with Cuba, and they talk about whatever they talk about, I just don't know. I won't come into that, really.
Well, you see, Mr. Kuba gave evidence to the effect that he was told by General Mhlameza exactly what Mr. Halley says, as I recall, and that something then came up in, is it on television, Mr. Halley? Or not yet?
The he later found out that, in fact, it was on television,
Yes.
that General Dramat had in fact been suspended. That was the 23rd of December, and that he had been replaced with General Banin Mhlameza.
Yes, I think the question arises from the fact that if the Minister of Police was the one vested with the power to suspend General Dramat,
Right.
certainly the Minister of Police is the one who knows once he has made a decision that he's going to suspend General Dramat. Now, if somebody else tells Mr. Kuba that something is going to happen to Mr. General Dramat, I don't know whether I said we must watch on television or whatever, and something does happen, and what happens is the suspension of Mr. Dramat. It seems to me that it's legitimate for one to say, but in all probability, there are very few people who may have known that the minister is going to make this decision or had made this decision until it was announced. So if it's not the minister who told this person, who could it be? So I think that's the angle, and I think Mr. Hali is seeking to get confirmation from you that your position is that you did not tell General Mhlameza, or if there was a reason for you to tell him, yes, you did tell him, and this was the reason. That's what he seeks to establish.
Thank you, Mr. Chair.
No, look, Chair, I absolutely have no reason to speak to another employee about the fate of another employee, really. I don't.
Yes. So you did not share that information with
I just
Mhlameza?
didn't. Yes.
Okay.
Now, we can exclude the possibility that General Mhlameza had simply guessed this, because he was already communicating that to Mr. Kuba on the 6th of December. And as it so happened, on the 23rd of December, when General Dramat was removed, who was he replaced with?
I'm sorry, just repeat that.
When General Dramat was removed, who was his replacement, acting replacement?
Oh, it was General Mhlameza, sir.
Very well. So the possibility of this being a pure coincidence seems highly unlikely, that other than on the explanation that General Mhlameza must have known that this was going to happen. Would that be fair to say?
No, it's not fair to say. In fact, I think it's unfair speculation.
So at the time, on the 6th of December, this apparently, and I thought I'd understood that the notice calling upon General Dramat to give reasons why he should not be suspended. I understood that that happened on the 6th, but apparently I'm wrong about that, and it in fact only happened on the 9th. But when you invited General Dramat to give reasons why he should not be suspended, was it your intention to ignore those reasons if he had in fact made representations or provided you with reasons?
Chair, I respect due processes, and I'm very particular about them. To an extent that those who care to tell you will tell you that I've always, in my professional function and duties that wherever I've been assigned to, avoided to have preconceived ideas about what needs to happen to a person who allegedly has committed a wrongdoing and so on. So when I say to you as an employee, these are the allegations. In fact, generally in the public service, we call it a contemplation letter. That these things have been brought to my attention, and because they've been brought to my attention, give me the reasons why I should not pursue this particular matter or matters, particularly in relation to whatever the specific issues would be, okay? So, I don't, in fact, I'm even much better than lawyers, I think. You would know this, Chair, because of your background as well in labor matters, that it is a common thing for lawyers to approach you and say, yes, you're the employer and you want us to assist you in this particular matter, but what do you want? And I always tell them, look, all I want is the fair processing of the specific sort of matter. So don't ask me about whether my intentions are to get rid of this person or any other thing about this particular individual, because the issue is what wrongdoing has been committed and what is it that needs to be done to rectify that particular wrongdoing. That's it. And fair processes are critical, extremely critical.
So I guess the short answer is you would not have had any intention to ignore representations if representations were made by General Dramati.
Exactly.
Yeah. Okay.
And do you recall whether General Dramati did in fact make representations to you?
I think I must have, because I think I eventually then wrote back to him in relation to an interaction that must have taken place. Of course, would appreciate that I'm no longer in government, and therefore the question of pieces of correspondence and so on, and documentation will be problematic. But I think he must have.
Now, on the 23rd of December, you in fact suspended General Dramati, replaced him with General Mhlemeza. But
Probably, I'm sorry, Mr. Halley, probably in the judgment, Helen Suzman Foundation, probably that is covered.
Actually, the judgment set out the entire history in
Yes,
terms of that.
yes,
So maybe I
yes.
can even make the copy available already.
it should be in the bundle.
No, I mean of Helen Suzman Foundation.
Yeah,
Oh, it is in the bundle. Okay.
I expected it to
But we made copies anyway.
There is one at page 273 for Helen Suzman Foundation by Prince J.
Yes, that's the correct
Yeah,
one.
okay.
So that judgment, it will, I
Has
mean,
got the
Principal J reproduced even the contents of the notice and
Yes.
all those things, yeah.
Yes, yes. Thank you, Mr. Mkhari.
Thank you.
Thank you, Mr. Chair. We'll look into it. I'll look into it a bit later, Mr. Chair. So, Mr. Nhleko, obviously you would have had a discussion with with General Mhlemeza before the date on which you suspended General Dramati. Correct?
I would have had what discussions with him
Yes.
about what?
About him taking over the acting role.
But how would I talk to General Mhlemeza about taking over the acting role in a position where General Dramati is occupying? How do I do that? In any case, even if it's yourself, how would you do it? Somebody is occupying a position and you're talking to somebody about occupying that position.
Let's hear the short answer, Mr. Nhleko, and I think the short answer might be, yes, I did speak to him, or no, I did not speak to him. And I think from what you are saying, you mean you did not speak to him. Is that correct?
It is correct, but I'm trying to establish the logical sense here that you have somebody occupying a position, but then it is alleged or expected that you would speak to somebody else about occupying that position.
Yes, but
You know,
see,
so it defeats the whole notion of your procedural fairness as well.
It may, but will make better progress if you are able to just say, I did or I did not. But for what it's worth, I can say this. subject to the question of the time frames, I can imagine that somebody who contemplates suspending a certain person from his or her job, particularly a crucial job, may, prior to actually making the decision to suspend that person, start thinking about who will I put in if I do actually suspend this person, and may begin to talk to possible candidates without necessarily saying, you will be replacing because no decision has been made, but wanting to make sure that they don't suspend somebody who may be in a crucial position and only after that start thinking who will replace them. So, but I'm just saying, I can imagine that kind of situation, but I think your answer is you did not speak to him, and in your view, there would have been no justification to speak to him at that time because Mr. Dramat was still in the position.
But could I come into exactly just this example you just made, Honorable Chair? When you contemplate, it's exactly that you're contemplating. You would not have taken a decision to actually put this particular employee on suspension. So the whole question of what ultimately happens hinges on the required submissions from the side of the employee about whatever the issues are, so that could also assist you to be able to weigh whether the reasons are weighty enough or not so enough to therefore not put that person on suspension. Okay? So there's no question of you therefore need to go to somebody else before you actually activate suspension and so on.
Yes.
Now, but also the second part of your example, and this is where I want to come in. The question of talking comes very late. Remember, these are your employees, and all their personal records are with you. So we are able to assess strengths, weaknesses, and whatever it is that you are looking at based on what you have before you. Okay? And then it is then that you would then decide that, in fact, it is employee X that can also fill the shoes in the meantime and so on. Okay? Now, I think the advantage with an institution such as the police, it's an order-based institution. So I don't want to go any further, but
yeah, but basically what you mean, you know which employees you have, you can order them to say, from tomorrow you report there.
I'm making this distinction, Chair, because you would appreciate that in the ordinary sort of industrial life, there could be a degree of variance as opposed to an order-based kind of institution and so on. I mean, at least my experience tells me that.
Okay.
Very well. So then, would it be fair to say, given your answer, would it be fair to say that prior to making the appointment of the acting appointment of General Mhlameza, you did not consult with him and you did not consult with anybody else that was part of the senior management of the SABC?
I wouldn't be sure about the entire sort of processes and so on, but, I know that, let me put it this way, the first time I saw him, basically, General Mhlameza, that is, was when I was doing provincial visits. I think he was the deputy provincial commissioner in Limpopo. Okay. That was the first time I came across him, and it was, of course, part of the ministerial program, as alluded to earlier on, for instance, in terms of when I came in and needed to understand the workings of the portfolio and so on. And basically that was it at that time. So the question of who else I must have spoken to, for an example, during the whatever period, it's possible that I spoke to a number of individuals within the police service themselves about maybe few individuals that I also wanted to consider. That is now at the point of the submissions having been received from General Adjournment, and it became clear that there was further work that needed to be done, and therefore it was necessary to put him on suspension.
Would you say that that discussion that you say may have happened would have happened at a time when in your own mind you had made up your mind that you were going to suspend him, that is Mr. General Adjournment, because you had studied his representations?
Yes, when it became apparently clear,
Yes.
as it would
Yes.
as it would turn out, yeah.
Yes.
But I'm certain that given the fact that he was also deputy provincial commissioner at the time, now the reporting lines are very clear. It's the national commissioner responsible and so on. So I would have had an engagement with the national commissioner to then say,
Yes.
yeah.
Would you have shared the information that you were going to suspend General Adjournment with the National Commissioner at that stage? And if yes, who else do you think you would have shared that information before General Adjournment was told?
Look, again, the sequence of events, I may not necessarily be quite sharp on them at this stage.
Yeah.
But institutional arrangement would have dictated that you speak with the national administrator of the police.
Yeah. National Commissioner.
The national commissioner, yes. And in relation to now what I would not know, and I can't recall whether I really spoke to her at the time of the contemplation or post-contemplation, but because we had regular sort of interactions and engagements and structured kind of meetings, it's very possible that I spoke to her about what had transpired and been brought to my attention, and therefore it necessitated that something needed to be done about the issues as identified at the time.
Apart from the National Commissioner, would there have been somebody else within the SAPS that with whom you would have shared the information that either you had decided to suspend General Adjournment or you were looking at that possibility?
No, I wouldn't have done that.
You would not have done that?
I wouldn't have done that. As again, it goes back to the point that I said, you can't engage with another employee about the fate of another.
Yes,
it's completely wrong. In fact, it then constitutes your whole procedural fairness kind of aspect and so on. So it's wrong.
It would not have happened. Now, apart from the National Commissioner, would you have shared that information with anybody else within the executive of cabinet government prior to informing General Adjournment or not?
Look, not at an executive level, if I'm understanding you.
Well, I'm talking about cabinet.
You're talking about cabinet, that I would go to cabinet and say...
Well, either cabinet as in the body or some individual or individuals in the cabinet, including the president.
Oh, okay, okay. So I think in a nutshell, you want to know whether, did I advise the head of state about the, okay.
Either the head of state or any other colleague within the cabinet.
No, it wouldn't have been any other colleague, it would have been the head of state.
The head of state.
Yes, and briefing him about these issues as they came up and so on, because
Yes.
it wouldn't be fair, for instance, to a president to hear from the media about either a contemplation letter being dispatched to a high police official or even for that matter, eventually suspension and so on. So it becomes important to then brief the head of state about this is what I've established and this is what the law says and therefore this is what I'm required to do.
So would it be fair to say the only people that you shared the information with in terms of the decision which you had either made but maybe not necessarily communicated yet to General Dramat, or that you were contemplating making, were the National Commissioner and the head of state? Would it be fair to say that's the position?
Yeah, I just couldn't get the first part of would it be fair to say
would it be fair to say you are saying the only people with whom you shared the information, either that you had already made the decision to suspend General Dramat, even though you might not have communicated to him at that stage, or that you were contemplating making a decision to suspend him, that the only people you shared this information with were the head of state and the National Commissioner? Would it be fair to say those were the people?
I think that would be a fair assumption.
Yeah, okay.
Thank you, Mr. Chair. Now, of course, having communicated that information to the National Commissioner and having communicated that information through to the head of state, one of the first questions that either one of those two would have asked you was, who are you going to replace, who are you going to put into the acting position as the head of the DPCI? Would that be fair to say?
No, I'm not sure whether they did that. I really can't recall whether anybody asked me that question. But with regards to the National Commissioner, indeed, I think I did share views with her about, and she also made some suggestions of other individuals that we could consider. Now, that's at the point when, I eventually had to make a decision about suspension. Okay. Yeah.
So are you saying that with regard to the National Commissioner, you did tell her who you were thinking of as a temporary replacement for General Dramat during the suspension? And in your discussion, the National Commissioner mentioned other possible names you could think of? Is that what you are saying?
No, I did.
Yes, okay. But you are saying that the head of state did not ask you about who would replace General Dramat during the suspension?
No, I don't recall him asking me as to, okay, so who are you going to place there for replacement?
Okay, all right. Mr. Halley?
Thank you, Mr. Chair. So presumably when you approached the National Commissioner, you already had in mind one or more people. She proposed additional people, and the two of you sat and discussed which was the best person to put into that position. Would that be fair?
Maybe I think it happened that way, yes.
Now, you would obviously have come with a few suggestions yourself Or was it only one suggestion?
There could have been few, I think. Could have been few, yes. Probably 2 or 3 of those.
And you say that as the ministry, who is the employer, I think you said, of the members, you've got access to their personnel files. Did I understand that correctly?
Yes, I could have access to personal files through the National Commissioner, of course.
So
I'm saying I could have access to personal files and profiles of individuals through the National Commissioner.
I see. So what you're saying is that if you wish to access a particular personnel file, you could do it through the National Commissioner, but you don't have direct access to it within your office or within your ministry.
No, I don't.
So you would have obviously called for these personnel files in respect of the people that you had in mind beforehand. In other words, before meeting with the National Commissioner.
I'm not sure whether, I think in a meeting situation, yes, because you would have, I think at the initial stages, you'd have an open general meeting about a few individuals, names, okay? But a national commission as an administrator would then go back and look at the actual profiles and the skills sort of levels and sets of people and so on, and then take it on from there.
Very well. Now, moving forward into January of 2015, because these events happened on the 23rd.
Come again, you said 2000 what?
Into January of 2015, the events that we've been speaking about thus far all took place in December of 2014. In other words, the suspension of General Dramat and the acting appointment of General Ntlemeza. Those took place in 2014. Mm-hmm. Now, in 2015, we know that from your testimony that you gave yesterday, we know that you never approached Mr. Robert McBride to discuss with him the fact that he had provided you with a report of which he was one of the signatories, that being the 18 March report. Mm. And you had these 2 reports, but you had never discussed with Mr. Robert McBride how the second report came about. That was your testimony yesterday, if I understood correctly.
Hang on one second. You were dealing with the reports earlier.
Yes, Mr.
And then I thought you moved to the question of the issue of the suspension of General Dramat, and that's why we were talking about what Mr. Kuba said. He was told by Mr. Ntlemeza. You now refer to the reports. Is that because you are moving back to the reports, or is it still under the issue of the suspension?
I may come back to the suspension, but I'm moving now chronologically into January.
Yes. You might be moving chronologically in terms of the dates and events, but I was thinking that you were following themes.
Yes.
Are you going to come back to the suspensions, or are you done to the suspension of General Dramat, or are you done with it?
We may come back to it at a later stage, depending on how we deal with certain other issues.
Yes, okay, all right. All right, proceed.
Thank you, Now, so you've got these 2 reports, which you already had as far back as November of 26th of November of 2014. We move now into January of 2015. What do you decide? You haven't consulted Robert McBride, who's the head of IPID. In fact, you haven't consulted IPID at all about the existence of the two reports. You start considering the possibility of an investigation and appointing a private firm to investigate the issue. Is that correct? We're in January of 2015.
Look, I think you may be incorrect in respect of two things. The first one, you say, I think earlier on you alluded to I think yesterday and even this morning, you alluded to pieces of correspondence and exchange between myself and Mr. Robert McBride. Now, and of course, now I'm dealing with that question precisely because in your formulation, you are then saying, I did not either speak to him or consult with him or something like that. Now, so what do you define? How do you define these pieces of correspondence between him and myself? That's one. The second thing is that you are faced with a situation here where allegations of the existence of the two reports are made. And senior individuals in the institution are implicated in the alteration of the report of the 22nd to produce the report of the 18th of March. Now, and I think we need to be alive to this thing that we are then talking about an institution whose image then is somewhat tainted, but also the issues of integrity become a focal point here in a sense. So, and linking that, this issue that I've spoken to, linking that to an earlier decision that I had taken, Chair, to process exactly those issues. How come we have with that situation? And the situation is in twofold. Do you have a report that recommends criminal prosecution, for an example? But you have another allegation and or report which in a sense says that report that you're referring to has been altered. And that also could be divided into two when you talk about an employee misconduct around that. Because then we have your employee who is alleged to have tampered with evidence and so on, or a report. So you therefore need to look into the institutional arrangements insofar as processing that particular matter is concerned. But also by further extension is that you also have possible sort of criminal issues arising out of that employee misconduct, you know, and so it goes. So I thought let me just respond in this particular way to try and clarify this particular point that Mr. Hurley has been pursuing.
I don't know what your plan is, Mr. Hurley. You may have a certain plan, but I want us to get into the meat of this issue of the reports.
I do.
Let's get to the meat of that report, because I've been waiting that we'll get there. Let's get to it, let's deal with it, and then move on to something else.
Thank you, Mr. Chair. Now, The two reports,
Maybe let me just say this, and for me, the meat of that issue encompasses, among other things, the question of what was the nature of the alterations, alleged alterations. Were they alterations? Can they properly be called alterations? Where was iPad entitled to provide the report of the 18th of March? Were they entitled to provide such a report? If so, under what circumstances? Were they entitled to say, well, there's something we are not happy with the earlier report. Here is our latest report. This is the one we want you to look at. You know?
thank you, Mr. Chair.
Was there a proper basis for the minister to seek an investigation of this issue by Workmen's? And then, of course, Mr. July will come later this week, the question of the recommendations that Workmen's gave to the minister. Was there a proper basis for it? Were there a proper basis for those recommendations? Could it be that there was some other agenda? Because I think one or more of the IPID witnesses may have suggested that there was something more than just genuine investigation of issues, and that the idea was to get rid of some of them. So I think let's get to that.
Now, when you decided, Mr. Nhleko, to hand the matter over for investigation to an external firm of attorneys, at that point in time, you had the two reports, one dated 22 January 2014, one dated 18 March 2014. At that point in time, you believed that there were alterations that had been done to the one report, in the alterations from the first report, which gave rise to the final product, which was the 18 March report. Do I understand that correctly?
The starting point is at two levels, Honorable Chair. The starting point is, why do you have two reports? So which is which between the two? That's your starting point. The second area of that starting point is why these two reports have got two sets of recommendations that are completely the opposite, sort of. Okay? So you have
conflicting recommendations.
Conflicting recommendations, yes. And it's from the one institution, one and the same institution. And the common denominator is a chief investigator who also appears in the first report, but also appears in this other report with a different set of recommendations. And the question is why? Okay, so you would start there first. Now, I think I had spoken to what I think I referred to as allegedly sort of employee misconduct, sort of, let me put it, in simpler terms, maybe suspicions of either an employee has, now, so you do need to get to the bottom of that issue. But because essentially the matter here, and I think it's just that there have been a number of misconceptions and misinterpretations about this thing at many different levels. But this issue of the two reports and the involvement of Mr. McBride, Mr. Kuba, Mr. Sisoko, and so forth, it's about employer-employee relations. That's what it is. And the employer, in this instance, the Minister of Police then, had a duty to then try and ascertain what exactly transpired in this particular instance, okay? So, even if you were to go outside and look for assistance, you will need a specific sort of, my English is running out, whether it's a dedicated sort of assistance. In other words, you'll be looking for a particular and specific competency, if I may put it that way. So for instance, if you have a lawyer called Zondo somewhere, okay, and is a labor specialist and so forth, you are likely to go that route as opposed to Mr. Harley, who's a criminal lawyer. And I'm just making an example. So you would have, in a sense, to also define a sort of some scoping of sorts in terms of what kind of a competency are you looking at to assist you in a matter such as this and so forth. So, and remember, the Honorable Chair, we had said when we started on this issue, because I think the issue of, let me try and, I suspect you nearly said something about my mic, Chair, so that's why I'm drawing it closer. Yeah. Now, I think when we started, you know, the issue of Vexman should not be seen only in the context of Vexman as a standalone out there. You have to understand the process. Process is a reference group producing a particular set of reports. And from there, you then evaluate, yes, you have these reports, but what else do you need in order to take an informed decision about these particular matters? So, and that exercise was entirely located within the Civilian Secretariat of Police. To then say, look, there are these issues and these matters institutionally. Look at how these matters are to be dealt with, so that we have, we needed to have some absolute clarity about what was the actual state of things around this particular issue of the renditions. So it should then be understood in that context that even the issue of Vexman itself cannot be separated from the initial work that started off with the appointment of the reference group, and it then developed further in terms of we wanted to have much more clarity on it. We then said, Honorable Chair, that we needed to know who and under what circumstances was the original report of the 22nd of January altered, and how the second report came about. So that's the starting point. So where did this thing come from, and so on? Now, and I think I've alluded to this thing, you also have, you know, the chief investigator appears in both reports. The second area is whether, by so doing, in other words, alteration, does that constitute misconduct or any offense? And if so, by whom? Now, you would also understand this, Honorable Chair, even from the labor law let me not say labor law, but from industrial sort of relations practice really. An employee, one of the considerations when you deal with disciplinary matters, that employee should be, one fundamental question is whether he or she was in the know or is in the know of an existing policy, for an example, pertaining to a transgression or alleged transgression and so forth. And that's why this issue became important, the question of whether any misconduct or offense would have been conducted by somebody, and if so, who's that particular person. The third area is whether there is prima facie evidence of misconduct and criminal liability by Lieutenant General Dramat, for an example, Major General Spear, and any other officers mentioned in the original report. Now, again, is the question of the original report, which made specific recommendations with regards to these specific individuals. The fourth area, the circumstances under which the report and the docket handed in the National Prosecuting Authority, and what happened to the docket whilst it was in the possession of the NPA. Now, the prosecutors, in the form of, I think, Advocate Mosing and Mweletsi, made statements in regard to how the issue of the docket was handled by them at the NPA. And there are references to a series of internal communication within the National Prosecuting Authority in trying to clarify this issue of the report of the 22nd and allegedly the second report, which is the 18th, the report of the 18th of March. The last area. We also needed to establish whether any other matter that would come to the attention of people assigned for investigation would be relevant to conclusions and findings. Sometimes when you have a scope for an investigation, you start somewhere, but somewhere down the line, you begin to discover other things that were not known at the time when scoping was being done, and so on. So I think this point really talks to that issue. And that's how the issue of the appointment of Waxman comes in. So I agree with you, Honorable Chair, that between yesterday and today, there's a lot of other things that we said and spoke about, but we've really been skating on the periphery here. The issue, both before this commission and the South African public, is it true that there were two reports? If so, what's the difference between these two reports? And thirdly, what is it that was done about it and what it is that is to be done about that? Because it's a matter that remains hanging and outstanding. Honorable Chair.
Now, I would imagine that if somebody who reports to me gave me a report on a certain subject, or made a report available to me on a certain subject, call it a first report if you want to, and then later gave me another report on the same subject. I would imagine that the first question that would arise with me is, does this second report replace the first report? In other words, can I throw the first one away, and is this your report to me, the latest? And if he says, yes, the latest is my report to you, throw away that other one, then I'll throw it away and look at this one. But if I have read the first one, I may say, let me not throw it away as yet. Let me read the second one and then take it from there. And then if there is a need for any clarifications, they would arise from there. Why didn't you regard the second report? And when I say second report, I refer to the one of the 18th of March, as the report that the IPED intended to be their report and no longer the first one? Why did you not regard the second report as the report that they intended as their final report to you or actual report to you? Because otherwise, why would it be necessary to have two reports? So wasn't the second one meant to replace the first one?
Chair, I will answer that question perhaps, in two ways. Maybe let's start with the last area, why the last query from the chair.
The last bit of the question.
Yes. Why I couldn't consider it as the second report as the final and whatever. Now the question is, what happens to the first one, or what happened to it? Because this very same one. And by the way, convention has it, Chair, that anyway in the world, if you produce a report at some point and you feel, hey, there are things that I would have to do whatever about and so on, maybe change or alter and so it goes. The first point of reference is to also state that we are nullifying the first one. That's the first point. Now, but in this particular instance, the legislative and institutional arrangement between IPED and the NPA says if IPED is conducting a criminal investigation, the NPA would assist them with prosecutors or a prosecutor. Okay? Now, so in other words, if you are then producing another report, you must still pull in those particular prosecutors and say, there's something wrong with this report, and whatever it is that you consider to be wrong or needs updating, whatever the case is, so that they themselves would also be part of a concerted sort of arrangement and so on. Now, that did not happen. So we keep, up until today, we keep on referring to two reports precisely because in the possession of the National Prosecuting Authority, they have the report of the 22nd. And then another report that then emerged later and so it goes. So that's my response to the second part of your question. And I think the first part of your question, Chair, I think I've alluded to this particular point. You already had allegations against this institution. Now, you therefore also needed to, as an employer, you also needed to embark on a particular exercise to establish the veracity of these particular allegations. And precisely because you are not as competent as you could be in terms of, just the finer detail around the particular issues of investigation.
Please don't forget exactly the point you want to make, but I just want to make sure I follow
Yes.
it. Which allegations are you talking about?
The allegations of the two reports
Yeah.
and the different sets of recommendations, Chair.
Yes, okay, all right, continue.
So you already have that, right? Those are serious allegations.
Well,
And-
I'm sorry, but remember that my question, and I hope I don't confuse you about the first part of the question and the second part of the question.
Okay.
But my concern is the second report deals with the same subject matter as the first report. Why are you not taking the second report as the report intended by IPED to be their report and not the first one? Because it's the same subject to the extent that there is some conflict between the two. They can't be intending both of them to be their reports at the time of submitting the second one.
Could I suggest, Chair, that we come back to this question? But maybe the
That's
starting
fine.
point really
That's fine,
should
that's
be
fine. Yeah.
an evaluative exercise
Yeah.
of what are these two reports.
Yes.
And then we will then need to come back exactly to the
Yes.
questions that the Chair
Yes.
is raising.
Yes.
Yeah,
Mr.
I
Hali,
have
just
this
make a note
suggestion.
of the question.
I've got no difficulty with going into the reports, but the question is, firstly, before we even get into a consideration of the report, we need to understand why it was considered necessary to refer the matter to Worksmans in the first place. Now, we know that we know from the evidence that's been given by Mr. Nhleko that there were allegations. We understand now that the allegations relate to the existence of the two reports. Now, if I understood Mr. Nhleko's testimony before, these were not allegations. It was a fact. He had the two reports. He had the signed report of the 22nd of January. He had the signed report of the 18th of March. He had both reports before him. Now, against that backdrop, if I might, Mr. Chair, you've got the two reports. It's not an allegation. You've got the two reports, and you've got the second report, the signed report of the 18th of March. You've got that on the 26th of November of 2014. Correct? That was your earlier testimony, sir.
No, I'm waiting to hear the question, sir.
Now, against that backdrop, are you suggesting that there are allegations that there's something untoward about those two reports? Because you've got the reports in front of you. You can look at them yourself.
Look, I've responded to this question extensively, Chair. I even outlined what areas needed to be considered in dealing with this particular question. So, in all fairness, Chair, I think let's deal with the reports.
Well, you see, as we go along, we might not all have the same recollection of what you said an hour earlier and yesterday. And an evidence leader, when he has a certain question, may sometimes want to make sure that his premise is correct and therefore might ask you to confirm that this is what you said before. So from your side, you might say, oh, why is he asking me again? Now, of course, I don't want him to ask you the same question all the time because we need to make progress, but sometimes an evidence leader does that just to make sure that his next question is not based on a misunderstanding of what you said earlier on. So I just thought I might clarify that.
I accept that, Chair.
Yeah.
I accept that very much.
Yeah.
And in fact, I would also venture to say that some of these questions are still relevant even after I would have delved into the report. My misgiving is that I suspect that between yesterday and today, there has been a concerted effort not to deal with these reports. Now, and I'm not talking about you, Chair.
Yes.
Okay. Of course, I'm talking about the evidence leader. And I think, for me, it's critical that clarity is put right across and out there around these particular issues. And that's why I'm saying, Honorable Chair, that I think some of the questions that you are asking are valid. I may not agree with them, but they are valid. But it's possible that they will also become much more clearer as and when we deal with the investigation report and the two reports. Because it's a wide-ranging amount of work that was done there. It includes issues of processing, even within the weather IPID and some sections of the police service, the National Prosecuting Authority, and so on. But fundamentally, it then deals with the disjuncture between the two.
Yes, but you see...
For me, I think that's one fundamental.
Yes, you had me earlier on. I said let's go straight into the issue of the reports, and
Yes.
When I say that, then we'll go to the investigation and so on. So I've no doubt Mr. Halley is looking into dealing with that. Is dealing with that, but. The shorter answers you give, the more progress we will make. Now, of course, there may be situations where you feel you have to explain, so on, but I also just need to tell you that your counsel is here. He is here to protect your interests. He is watching, and when he thinks there is something unfair that is being done to you, he will. He's very experienced counsel. He will look after your interests. I'm not saying that you may not raise an issue when you feel that there's an issue. But let's try to the extent possible. Even when you think the question is being repeated, if the answer is a simple one, yes, I said so, I didn't say so. Let's try and do that. Yeah.
Thank you, Mr. Chair.
Okay.
So, Mr. Nhleko, what I'm trying to ascertain is the very reason why it is that you had referred this matter to Worksmans in the first place. As I understand it, you said that there had been allegations. The allegations that you were referring to were the allegations of the existence of the two reports. The two reports you had in front of you, so I'm trying to understand, since you had the two reports in front of you, surely you could simply look at the two reports yourself. It might require further investigation after you've come to a conclusion, but you could certainly look at the two reports yourself and ascertain whether, quite apart, because the conclusions are clearly different, but you can ascertain from the two reports what those differences are, surely.
Now, I'm trying to figure out, Honorable Chair, how do I give you a shorter answer to this question? Of course, I'm not saying give me a prescription.
Do your best.
I'm not suggesting. Yes.
Yeah.
Now, how do I give you a short answer to this question? And I think this question, we've been toing and froing around it and so on. Remember that this very same question that is being posed by Mr. Halley talks to the issue of the need for the docket so that we are able to go through this issue of the two reports. Now, so in a way, this very same question which had been attended to at an earlier point is being brought back. And yeah, that's my somewhat of a misgiving. Yes, you can have a look at reports, but you need much more further detail than what is written in the reports. And that's where the question of investigation comes in.
Let me ask this question. What was your understanding at the time you were dealing with this issue as to whether IPED would be entitled to change their mind about recommendations that they may have made in an earlier report? Do you remember whether you had a view or you didn't have a view about whether if they have submitted a report and later on they had a change of mind about any recommendation, they would be entitled to then say, you know, we have realized that that recommendation is not sustainable, and here is a report that reflects what we consider to be our final view and recommendation on the matter.
But Chair, a report doesn't start from recommendations. Recommendations is the final product of some work that would have been done. Now, and correctly so, you know, we kept on going back to this question that says, okay, so you have this report, it's filed there, and it's not withdrawn with the National Prosecuting Authority. But the recommendations of this very same report, as opposed to the report which came later, which is now the 18th of March, are different. Why? Now remember that I had spoken to the question of an institutional arrangement here, which says that the prosecutors that the NPA would give them as IPED, for an example, must also be part of the generation of, I suppose, any other report if they would be after that. Because why would they be involved in one report and they're not involved in another around the same issue? That's
yeah.
Well,
But my question is, are you able to say that at that time you had a view or you didn't have a view on whether IPED was entitled to change its mind on parts of a report or on its recommendations if after they've submitted a report, for certain reasons they realize that their view or recommendation would not be sustainable or is not justified? Is that something that you know that you did have a view that they could do that, or is it or you don't know whether you had thought about it, or you know that you thought they could not do that?
No, I certainly don't know whether I really thought about it, Chair.
Yes.
Except that,
Yes.
for me, the critical question was resolving the issue of the two reports.
Yes. As you sit there now, as a matter of principle, do you see anything wrong if the position, if you were to be told that maybe the position is that IPED would or was entitled, if they changed their view on a report that had been sent for whatever reason, to change or to provide a report that reflected their revised view? Well, what would you say about that proposition as you sit there?
And I think that's very hypothetical.
Well, we have
I
to
think it
start
is.
there.
Yeah, but maybe let me try.
Before you try, let me
Yes.
say,
Sure.
you see, for me, and it may be that for Mr. Harley as well as for Mr. Mukari, because we are in the legal profession, but maybe not for you. You know, for me, when I when I had evidence last year about this report from the IPID witnesses, one of my first questions was, are they entitled to change their view? Are they entitled if they discover, for example, that the report they have sent in has a flaw? Are they entitled to convey, whether to the NPA or to the minister, to send a report that reflects their view after some intervening event has happened, or after they've had a chance to reflect on it? Because if they are entitled, it may be that should be the end of the matter. If they are not entitled, it may be that there should be further questions. Another question that I raised when the IPID witnesses were giving evidence was this issue of alteration. They are said to have altered a report. So I said, well, maybe somebody will explain to me, and maybe there's just something that is missing for me, because for me, if you have a certain report and maybe you cross out certain things, maybe that's alteration. If there's a report, then you create a different document, another report. That seems to me it's a different report which may have some differences with the first one. But maybe that's technical, but it's something that I want to understand. But let's deal with that in due course. So I come back to simply the question first, to say, you, as you sit there, do you have a position on whether they would have been entitled to give you another report if an earlier report that they had done, they subsequently thought there was something wrong about it?
Sorry, Chair, I don't know.
Sorry.
I just wanted to come in, maybe
Yes.
what I say may be of assistance.
Yes.
The issue of whether IPID was entitled to produce another report. My understanding is that it is a legal issue. So, Mr. Nhleko may give his view. As I understand the law, on a legal issue, it doesn't matter what the witness say. So if the law says something else, then the law says something else. So maybe if he can focus on the facts himself, then the conclusion, which is going to be a legal conclusion, will then be debated by the commission itself. But the commission is now going to ask itself a question. What does the law say in respect of reports which are produced by IPID? Is IPID entitled to produce another report which contradicts the first one? And if so, what is the authority for that? So that is going to be a debate among the lawyers.
No, I understand what you're saying. You will have noticed that my question was not was framed with a view to getting his own understanding, which may be right or may be wrong. The lawyers will debate whether it was right or wrong afterwards.
Okay, now
But
understand
just his
it.
own
Understand
understanding.
that.
Yes.
I think he must answer. I think he must answer the question
Yes.
because clearly he must have had a view.
Yeah,
I mean,
yes.
either right or wrongly, he must
That's
have had a
right.
view.
Yes,
I think he must
yes.
answer the question so that we can move on.
Yes. Thank you, Mr. Mukari.
I'm so happy I'm not a lawyer. I'm very happy.
Well, don't be sorry for not being a lawyer.
answer this, because I want to try and practicalize this thing, and of course I'm not going to be legalistic, as you would know. I'm not. I know nothing about law. A report of this nature is constituted by statements from people, whether witnesses or whatever. So let me give you an example. If you we are constituting a report and there's a Colonel Madilonga who then says, no, I witnessed the entry of the Zimbabwean police, and I picked up the phone and I called this particular general.
I'm sorry, Mr. Nhlego, I know I'm stopping you.
Okay.
But I'm trying to make sure we make progress.
Okay.
My question is whether at that time you had an understanding of whether they were entitled or not. The answer could be, yes, I did have an understanding, and my understanding is they were entitled under certain circumstances, or my understanding was they were not entitled. So that's what I'm asking.
No, I think the fair answer then to that, if the Honorable Chair says
Yes.
I shouldn't try and provide a practical
Yes.
example, is that I had no view.
Yes, okay.
Yes.
No, that's fine. Yeah. Thank you.
Thank you, Mr. Chair. Now,
And could I also suggest, Chair,
Yes.
another
Another
break? Then?
We are at 7 minutes to, or 9 minutes to 1, so another, I wanted to say to you that some people call it a comfort break, but a previous witness in this commission, long before coronavirus and COVID-19, said, could we have an opportunity to wash hands? He wanted an opportunity to wash hands.
Exactly.
So
Sanitize.
with COVID-19, there is a lot of need for washing hands. so I think in that there are two options depending on your situation. We can go up to 1 o'clock and then take the break, or if the situation is such that let's stop now, we can stop now. You'd prefer now?
Yes,
Okay,
yes,
no,
very
that's
much
fine.
so.
Let's take the lunch adjournment and then we'll resume at 2 o'clock.
thank you, Mr. Chair.
Thank you.
Okay, we adjourn.
Thank you very much, sir.